Welcome to the EDRM webinar series. Today's webinar, sponsored by Ipro, is Moving Data Across Borders, No More Safe Harbors. My name is George Sosha, co-founder of EDRM, and I will be moderating this webinar today. Before we get into the webinar itself, I have a few housekeeping items for you all. If what you see on the screen isn't quite large enough for you, if you look at that window inside a window in the lower right-hand corner, there's a little gray rectangle with arrows on the four corners of the rectangle. Click that rectangle. It will enlarge this window to fill the screen. Hit escape, and it will bring it back down again. We want your questions early. We want them often. If you look at the upper left-hand corner of that window in the window, there's a button that says Ask a Question. Click on this button, type in your question. I will be monitoring the questions. Our speakers will keep an eye on them as well. And I'll do my best to interrupt and ask as appropriate the questions as we go through the webinar. Sometimes we don't get to all the questions, but we do the best we can to cover them. Occasionally I'll combine two or more questions into a single question. And sometimes if the questions are too self-serving or too far off point, we might not get to them. The webinar is going to be recorded. The recording will be available at the same location through the same path you took to get to this webinar. We have a series of attachments available to attendees of this webinar. You can go to the attachments at any point during the webinar, or you can come back afterwards. Some of these are files you can download. Some are links to web pages. Included in the attachments is a copy of today's PowerPoint presentation, so you don't need to be trying to grab that with screen captures or whatever. If you can go to that later if you choose to do that. Once in a while, people have problems with sound. We do monitor the sound. Rarely is there an actual transmission problem. Sometimes it's a question of people's bandwidth or the vintage browser they're using. If you do have a sound question, our recommendation is to turn the sound off, turn it on again, close your browser, open the browser again. One of those two almost always takes care of the sound issues. With that, I'd like to turn this over now to our speakers to have them introduce themselves, and then we will move into the webinar where already we've got some questions waiting for us.
Well, thank you, George. My name is James Daly. I'm Senior Counsel, Cypher Shaw, based in Chicago, dealing with our global privacy and security group, as well as our international e-discovery and information governance group. I've been working in this area full-time since about 1995, so on some of the earliest cross-border transfer situations following the implementation of the EU Data Protection Directive that we'll be talking about a little bit later. My background is technology background before and actually throughout law school. Got a master's in computer information management, which I try to blend with a similar passion for the law in helping clients reduce risk, contain costs, and ensure compliance with various data transfer and privacy regulations. Let me turn over to Emily to introduce herself, and then I'll lay the table with respect to why this issue is so important this time.
Thanks very much, guys. My name is Emily Fidelis, and I'm an associate in the New York office of Baker & Hostetler. I also work in the discovery, cross-border, data privacy, information governance areas, and prior to working in New York, I was with a firm in Geneva, an office of a different firm in Geneva, Switzerland, where I was doing a lot on the ground, doing a lot of cross-border work and gaining expertise there.
Well, thanks, Emily. So suffice it to say, and this is not news for many of you, there is a existing and longstanding conflict between some of the U.S. discovery laws and even discovery mechanisms, both in civil litigation and in the criminal context, on the one hand, and with data privacy and data protection regimes in the European Union and elsewhere around the world. The reason for that is a rather long discussion, but suffice to say that before and during World War II and then thereafter, during the Cold War, there were a lot of documented abuses of the gathering and use of personal data with respect to German and East German citizens. And that led to a backlash and a concern, because sometimes that information was used to, in effect, determine who was going to live and who was going to die. And because of that, this issue really causes shivers to run up the spine of those in the EU that have memories and sensitivity to that potential abuse that can become real. For that reason, among others, the European Union in 1995 promulgated what they call the EU Data Protection Directive. It was actually made effective in 1998, but the idea was to have at least a minimum standard across all the European Union countries for the handling of personal data. And personal data is considered in the European Union and most of the rest of the world as something that is entitled to the protection on the level of an individual human right. So I think even more broadly, perhaps, than a constitutional right that we have here in the United States, it really goes to the core of their fundamental charter as European citizens. This is actually administered in each country which has its own data protection authority or data protection department. Those departments and the countries have the ability to exceed the minimum standards set in the Data Protection Directive. And so it's become kind of a patchwork quilt with a lot of differences, modifications, and variations, say, between Germany or Italy or France or the UK, at least while it's still a member of the European Union, in terms of how to navigate the data protection laws and in terms of the severity of the conflict with U.S. Cross-border discovery rules. As you might imagine, this conflict was exacerbated, and even to the level of the Supreme Court in the Aerospatiale case, involving a request for data that was housed in Europe. And the question was, well, should this data be compelled to be moved over to the United States for the purpose of U.S. litigation, or do the rights of the European data citizens and the European countries to protect that information, does that prevail? And they came up with a five-part test based upon restatement principles, and it's been game on since then. There are a lot of other issues and nuances that we'll try to touch on throughout the presentation, such as the existence of blocking statutes that prevent any kind of pretrial discovery of information in certain European countries if it's to be used in a judicial or administrative proceeding in the United States. And then also we'll be talking about the General Data Protection Regulation that was just adopted in its final form and will become effective in May of 2018, that raises some of those similar questions.
And to drill down a little bit, sorry, to drill down a little bit on the Data Protection Directive, Jim touched on it, but just to really bring out the impact it had, it defined personal data very broadly. So includes any information that would identify a person by reference to an identification number or to one or more factors specific to physical, physiological, mental, economic, cultural, social identity. So very, very broad. And another important piece of it was the processing of personal data. And it defined processing as any handling of personal data outside the normal course of how it's managed and used by individual data subjects, so outside of normal sort of employee use of it. And the directive also dealt with the transfer of personal data outside the EU, placed certain restrictions from transferring it from EU to non-EU countries. And in order for this transfer to be legal, the country receiving the data must have been deemed to have adequate level of protection. And that caused some issues because it wasn't clear immediately after the passage of the directive that if U.S. companies doing business in the EU did provide adequate protection for this data. So if you think about U.S. companies dealing with the EU, two main reasons they would transfer data would be sort of human resources data of European employees and then European consumers' personal data. So the question became, did the U.S. provide an adequate level of protection of EU citizens' data?
And to kind of expand on what Emily has told us, it's kind of important to remember that the EU Data Protection Directive is based upon kind of really five main pillars or principles. One is proportionality, a second is accountability, third is transparency, four is data integrity, and five is data minimization. So what does that mean? That means that only information that's truly relevant and proportional to the needs of a case should ever be transferred. There should be accountability for how it's transferred and protected, even to the point of physical and electronic security. There should be transparency between all concerned as to what's happening and who's going to be using the data for what purpose, so that the data subject, or in most cases employee, who is deemed to own that data, is aware at all times of what's happening. Data integrity, there should be sufficient control so nothing gets modified or changed or diluted in terms of the data for its particular use. And then data minimization, again, the idea of culling out all those things that don't relate at all to, for instance, claims and defenses in litigation or a regulatory proceeding, and reducing, therefore, the risk of what is being moved across the pond from Europe to the United States in any particular situation. There's one group that's established by the EU Data Protection Directive. It's called the Article 29 Working Party. That's established under Article 29 of the directive. And it's made up of representatives of all of the different European member states. And they meet and they issue opinions which don't have the full force and effect of law, but which are very persuasive authority in terms of reflecting the consensus of the various data protection commissioners in Europe. And so there, for those, there is an important website. I don't think it's in the materials, but if you might write down www.europa.eu/justice, that will give you a window into those various opinions that have really have been written since 1998 and following. So
we have a question here, by the way, which is what's the difference, or what's the relationship between the directive and the regulation?
The directive is a statement of principles and minimum standards that can be exceeded by each individual member state. Each member state was required to adopt the directive, but they were able to adopt it in a way that they could make changes, so long as the changes were additional to and not in conflict with the directive itself. On the other hand, the regulation is a uniform law which is intended to create a one-stop shop across all of Europe, so that there isn't this patchwork quilt of, say, Italy having a different procedural mechanism for dealing with review of transfers, and Germany having another. So while there still will be a few minor modifications in certain contexts, say in the context of workers' rights in Germany, for the most part, it will be much more of a uniform, even playing field throughout Europe. It'll certainly be helpful in terms of predicting on the behalf of U.S.-based multinational companies what they need to do.
And in terms of the directive, that's where the DPAs come in that Jim mentioned earlier, the data protection authorities or the data protection departments in each individual country. The idea being they're best suited, they're on the ground, and they're better able to adapt the directive to suit the needs of their citizens. And again, to reiterate what Jim said, it's not in conflict with the directive, but just in addition to or enhancements of the protection that the directive offers all EU citizens.
That's right. And very early on, it was recognized that, unless we have some way of transferring personal data from Europe to the United States in the business-to-business context, as well as other contexts, this is going to have a damaging effect on international commerce. In fact, when you consider that the Europe Economic Area represents over 50% of the global gross national product, even larger than the U.S., and when you consider that restrictions on the free flow of personal data for business purposes is estimated by various nonprofit groups to have as much as a 10% negative impact on global gross national product, it was apparent that something needed to change. And so very quickly the United States, through the Department of Commerce and the European Commission, the executive branch of the European Union, engaged in negotiations that led to the Safe Harbor Framework. The Safe Harbor Framework was adopted in the year 2000, and it was intended to provide a means by which, if U.S. companies followed this framework, they would be deemed to have sufficient and adequate protections for the transfer of personal data. Now, there are a few different issues involved in this. First of all, the Safe Harbor Framework only applies to companies that are regulated by the Federal Trade Commission or the Department of Transportation. So it wouldn't include certain companies such as telecommunication companies or others that aren't regulated by those two agencies.
Jim, as you move into this and for the materials that follow, I'm going to pose a question that was asked at the beginning of the webinar, which is, I'm interested in how the new rules will affect cross-border internal investigations. Specifically, what should a chief compliance officer know, and how should he or she manage gathering data in future FCPA investigations?
Well, I presume the questioner is asking in relation to the General Data Protection Regulation when they refer to the new rules, because that's really the big change that's coming down the road very quickly. It will have no, the impact will be that it will provide and require more documentation with respect to the purpose of the transfers and the manner in which the transfers were arranged. So whether it's in the Federal, Foreign Corrupt Practices Act context or in a cross-border litigation context, there'll be increased scrutiny on things such as in-country culling of information to minimize as much as possible that which would be transferred only to that which is truly relevant to be used abroad. There'll be increased scrutiny on the manner in which that information is segregated and searched, increased scrutiny on notification of the data subjects or employees as to what's going on. There'll be increased need, for instance, to expand that bubble of protection from Europe to the United States. Some things suggested, for instance, that your compliance officers should be aware of. It's initiatives by the Sedona Conference and others and their principals to seek protective orders in U.S. litigation, requiring special handling of EU personal data, particularly EU personal sensitive data that would relate to the most sensitive aspects of a person's life, sexual orientation, financial information, medical information, and the like. So I think it'd be fair to say that it does not reduce the obligations. It will increase the obligations, and it will also increase the consequences for failure to provide that level of transparency and accountability and proportionality and data minimization, those principles that I talked about a bit before. So suffice to say that from year 2000 to 2015, the Safe Harbor framework was in existence, and it provided at least a basis for those transfers of personal data from Europe to the United States. And again, it was intended for the business-to-business context. There were a lot of complaints that were made during that period of time, such as the Europeans, and many of them didn't think that it was aggressively enforced or vigorously enforced by the FTC or the Department of Transportation. Second, there was concern that there wasn't really adequate safeguards being placed on the data in the United States, particularly in the litigation context, when that information was passed onward to others, such as opposing counsel, governmental agencies, vendors, and of course, these concerns, were increasing and coming to a crescendo by about 2013, when there were the Snowden revelations. And I think one footnote before we have Emily give us a little bit more background about that event and its impact is that the Safe Harbor framework, you think of it in terms of U.S. companies self-certifying to the Department of Commerce, subject to the enforcement of Federal Trade Commission or Department of Transportation, that they are going to, in essence, protect the same rights of EU citizens that EU citizens have abroad. There certainly was a complaint, though, between 2000, after 2000, that European citizens didn't seem to have adequate redress in U.S. courts, and then that's an issue that's been addressed recently in terms of the Privacy Shield negotiations that we'll be talking about. But that's some substance of the Safe Harbor framework, its purpose. And Emily, if you could tell us a little bit more about the context of the Snowden revelations and its impact in 2013.
Certainly. So as Jim said, there's growing concern from EU citizens that they're not getting the protection that they should be, that things aren't being enforced as vigorously as they would like to protect their privacy. And in the midst of all this, in 2013, we had the Edward Snowden revelations, where, of course, he came out and exposed U.S. government surveillance and the depths of the governmental access to personal data. And there was already concern, but this just amplified all the concerns that the EU citizens had about their privacy rights, about the Safe Harbor framework, and led to increasing calls for its overhaul. And so in the midst of this context, Snowden was 2013, as we know. In the following year, in 2014, we meet this Austrian student named Max Schrems. And just to give you a little background before Jim launches in on the specifics of the case, Max Schrems was a Facebook user, like many of us, and he complained to the Irish Data Protection Authority that Facebook transferred his personal data from their Irish subsidiary to the United States. And he was concerned, again, in the wake of Snowden, in the wake of there's this exposure of the U.S. government surveillance, Schrems was concerned that the government could the U.S. government could improperly access his personal data. And then the Irish DPA kind of backed off and said, well, Facebook is a member of the Safe Harbor framework, therefore they have an adequate transfer mechanism of data from anywhere in the EU to the US. And then Schrems appealed his decision, and that led to many changes, as we know. Jim, will you talk about those, please?
Yeah, I mean, probably the key change from the Schrems involvement was the fact that this was raised to the level of the European Court of Justice to determine whether the Irish DPA should take some action. And what happened next was a little bit unanticipated in some circles, and that is that ultimately the Court of Justice of the European Union determined that the Safe Harbor framework was not valid. And this decision came down on October 6th of 2015, but it immediately invalidated the Safe Harbor framework for the reason that it found that there wasn't sufficient evidence that the European Commission had really done a due diligence investigation or compliance monitoring to validate that it in effect maintained the same level of rights of the European citizens in the United States for that data that was being transferred. And one of the main reasons it gave for that were the Snowden revelations of the alleged unfettered, unrestricted access and surveillance by the National Security Agency and others in the United States of email, not just of U.S. citizens, but also of European citizens, once that data was being transferred. There were also issues about, in a recent case that's still pending, about the extraterritorial jurisdiction of the United States through the Department of Justice to subpoena email of an EU citizen that resides on a server, for example, in Ireland or in Germany or some other European country. The other main development was a clear statement that the individual country states, individual member states of the European Union, have sufficient sovereignty, even in the context of the Union, to have and keep jurisdiction over the review of all EU Commission adequacy determinations. So not just this adequacy determination in the form of the Safe Harbor framework, but also adequacy determinations in terms of past pronouncements of the European Commission that, say, for example, Israel has adequate safeguards and therefore data could be transferred directly to Israel without any additional mechanism, or a number of other countries, Argentina and the like, where those determinations have been made. Really only a handful of other countries, but it certainly opens those up to some further review as well. But it also raises the specter, just to fast forward a little bit or give you a preview, that whatever privacy shield arrangement is arrived at may also be subject to scrutiny and be raised as an issue as to adequacy before the Court of Justice of the European Union going forward. So that's a really important principle that had not been clarified until the Schrems decision. That left us obviously in a bit of a limbo situation where there really wasn't any immediate mechanism that was a broad one for business-to-business transfers. The only mechanisms that existed were model contract clauses and the binding corporate rules. Problems with those are that model contract clauses are intended for kind of ad hoc transfers, not consistent, regular, or large transfers. And a problem with binding corporate rules is it takes so long to get them enacted because they have to, in effect, be ratified by all the member states of the European Union, and they have to create a framework that is global and not just bilateral between the European Union and the United States. So that's where things have stood since October 6th of 1995, and there was a rush to try to develop a compromise known as the Privacy Shield. And that Privacy Shield has a few different aspects that we ought to know about. One is that, first of all, it has not yet been fully agreed upon. It has not yet been fully adopted by the European Union. In fact, there's a lot of criticism about it as not being any stronger than the Safe Harbor framework was. It does, however, allow for European citizen redress in U.S. courts for alleged violation of their data protection rights. It does require additional enforcement and oversight by the Federal Trade Commission and Department of Commerce of actual implementations in the United States. It also involves broader reporting to the European Commission of the results of those investigations. Another thing it does is it mandates that there are, in some cases, data protection officers that will need to be involved in the process of validating the procedures that are involved. One thing that has been raised, however, is the problem of cloud computing and cloud computing providers that, like Microsoft Office 365 and others, Amazon, where email is stored globally, and it isn't always easy to determine where that information is at any particular point in time. A lot of those issues are still very much up in the air in terms of what standards might be going forward, and how the Privacy Shield would deal with those sorts of situations. Some have suggested that the Privacy Shield might in effect become a privacy sword that could be used by European countries and European citizens to further complain about and attack, and this time with the ability to file class action lawsuits in the United States, the practices of some U.S. companies in the handling of the personal data, and ups the ante for U.S. companies to understand what the process and protocol is for managing EU personal data when it is on U.S. soil and when it's in the care, custody, and control of U.S. companies.
So with the private, maybe I'll just ask the question that's been posed rather than characterize. Is there a mechanism in place to deal with the conflicting interests of the orders of U.S. courts and the EU privacy laws? It seems like the global companies can't win. The choice is to violate a court order or face large fines from the EU.
Well, that's right. It's exactly right. They're between a rock and a hard place. Either they take the risk in the U.S. of sanctions, or they take the risk in the EU of significant sanctions and fines. In some countries, it has even risen to the level of criminal prosecution, such as in Italy, where the privacy officer for Google was prosecuted for not taking down certain personal data from Italy's version of YouTube quickly enough. So, yeah, it is a situation where there isn't any clear answer. That's why in 2008, it's why in 2005, myself and a few others were involved in founding the Sedona Conference Working Group 6 on international data transfers and cross-border discovery. And we developed a framework for those types of transfers that was received with a lot of interest and with a lot of approval by the Article 29 Working Party. They invited us to speak to a plenary session and that led to further dialogue with them, leading to the development of the Sedona International Principles, again with their full involvement. Those were published in 2011. Both of those documents, the framework document and principles document, can be downloaded free of charge from www.thesedonaconference.org, and that link will be part of the materials you'll have access to. But suffice to say that those initiatives try to find that way forward and create kind of a bill of lading concept for protection of that data, including, one of the things I referenced before was getting protective orders from U.S. courts with respect to the handling of the personal data, ensuring specifically the security of the data, identifying and protecting the onward transfer of that data, providing for the return or destruction of that data following its use for a particular purpose, and ability of the data subjects in Europe to be aware of where that data was and how it was being used. Those sorts of things were included in the Sedona Principles as a means of trying to bridge that gap. And then, quite frankly, in 2013, with the Snowden revelations and all that's happened since then, certainly those efforts have stalled a bit, but they have resumed now, which is a good news. And many of those data protection commissioners that were initially involved have re-engaged and will be part of the Berlin Sedona Working Group conference coming up in early June of this year. By the way, there are additional spots left for those that might be interested in attending that. Only a few spots left, and you could reach out to myself if you have any interest in attending. There should be some information that is in the materials for you to access about that.
And just to piggyback on Jim's response to that question, basically what you're left to argue in U.S. courts is that even though there are European data protection laws that restrict the disclosure of European citizens' personal information in discovery, the argument's been made in U.S. litigation that the laws are rarely enforced. Now, this is met with some success, but by and large, in the U.S., we just see judges saying, we need this discovery, we need this information in litigation, so you're going to get it regardless of what the laws are in Europe protecting EU citizens' data. So, as Jim said, you really are stuck between a rock and a hard place, and there are arguments you can make, but ultimately it comes down to choosing who you want to face, what authority you want to face, and who you want to obey and disobey.
Yeah, global companies clearly are at risk, whether they're based in the U.S. or whether they're with interests in the EU, or whether they're primarily based in the EU with large interests in the United States. There's no question they're at risk, and so it's a matter of how can we best mitigate that risk? How can we put in place as many things as possible to at least indicate that we respect and recognize the rights of the EU citizens to protection of their data, and that we have done these things that we think are reasonable and proportional to help manage that risk, realizing that there's a trade-off, and that trade-off is the free flow of commerce, which means more jobs for European citizens and U.S. citizens, means more economic growth to the benefit of the U.S. and the EU. So I think one of the questions that also remains right now, and it's a difficult one, is that companies that previously have self-certified under the Safe Harbor framework are in a quandary as to what to do, because as many of you know, that self-certification has to be made every year, and you have to certify certain controls and efforts with respect to both your privacy policies, procedures, processes and compliance in order to obtain that recertification. Now, many of our clients, for example, say, well, if the safe harbor framework has been invalidated, why should I have to recertify under it before the Department of Commerce? Or, what benefit does that gain? Why should I go to that extra cost of recertification? And the reason you need to carefully consider it is that the Federal Trade Commission and the Department of Commerce have been sending out notices to companies that have not renewed their certification under the Safe Harbor framework, reminding them that that framework is still in place, and if they're making representations that they're handling EU personal data in compliance with those framework principles, that they may be violating the public trust and involved in an unfair and deceptive trade practice. So the FTC is taking the position that, whenever you are making a representation as to what you're doing, and that representation has substance in the United States, which it claims this still does, that if you're not doing it, you need to remove those representations or otherwise be subject to FTC enforcement action. Right now, the Department of Commerce on its website is identifying those companies that have not recertified under the Safe Harbor framework, and it's a bit of a trap for the unwary that you should be aware of. And you should take a look at your privacy policies in terms of the language that's currently there that might relate to the Safe Harbor framework or compliance with Safe Harbor framework principles, and adjust or modify it as needed.
And just jumping in there, the Safe Harbor framework, it's easier in terms of you can sort of just have a single line in your privacy policy saying you self-certify and you have adequate protection. But under the Privacy Shield, there's a lot more required. It requires a lot more information from companies. You have to have a list of data that the companies collect and the purpose for which the data is collected, and how an individual can contact the company with inquiries on the data, and relevant EU entity that can respond to an individual's complaints. So there's a lot more involved for companies and organizations under the Privacy Shield to provide that transparency and to address some of the concerns that were raised under the Safe Harbor framework, with the idea being to provide more communication and transparency to the EU citizens about the protection of their data. So that's one notable difference between the two mechanisms that companies should be aware of when crafting their privacy policies and dealing with data transfer mechanisms.
And there's another mechanism that's been added in the Privacy Shield discussions, and that is having a U.S.-based ombudsperson that is full-time and whose staff is dedicated to handling inquiries from European citizens with respect to the handling of their data. That kind of transparency and maybe workflow process has not heretofore been in place, but this is an effort on part of the U.S. to try to indicate that they're serious about helping to provide that level of communication that Emily talked about.
And a further effort that the U.S. is undertaking is a joint review of the EU and U.S. government entities of the Privacy Shield to continue to make sure it's meeting the needs of the European Union DPAs and to address any issues that are arising in the practice of the Privacy Shield. So yet another way the U.S. is saying that they are in fact serious about protection of the personal data.
We have an additional question. I was going to say we have an additional question here, which is, would filing cases involving cross-border data under seal potentially help resolve the EU citizens' concerns of their personal data being exposed publicly in the U.S.?
I think that is going to be subject, obviously, to a lot to the discretion of U.S. judges. And at least my experience has been that there has not been a great amount of willingness to put documents or information under seal rather than just under protective order, unless there is clear and present danger to individuals or to law enforcement initiatives of national security, or clear and present danger to loss, irreparable loss or damage to property, intellectual property, or otherwise. It certainly would be one way of trying to help protect, say, the crown jewels of a European company's recipe for or plans or specifications for what they manufacture, and they could certainly ask for that in addition to the protective order, or ask for additional provisions under the protective order dealing with that. But unfortunately, I don't think that's going to be kind of a omnibus solution in most cases. One other thing in terms of the Privacy Shield that has been an important development is the Judicial Redress Act, which was signed by President Obama after being passed by Congress, and that was certainly one of those issues or thorns in the side of the European Union with respect to the Safe Harbor framework that now has been removed. In addition to that, there is underway what's called an umbrella agreement between the EU and the U.S. Dealing with transfer of data for law enforcement purposes. Again, not business to business, but law enforcement purposes. And so all these developments, I think, are hopeful in terms of us reaching an accord, but it's not, it'd be fair to say, it's not going to be the kind of carte blanche and long-term accord that we had between 2000 and 2015 under the Safe Harbor framework. There's going to be a much more and much more vigilant oversight of what's going on. I think those of you that are involved in cross-border litigation or regulatory investigations will also have to beef up your protocols and processes because of the many layers of onward transfer of that data once it gets to the U.S., whether it be to a law firm or, as I said, to a vendor or expert witness or opposing counsel. And that battle has yet been fought. It has yet been raised specifically, but I think it's going to be one of the next battles. So this might be a good point to say a few words about the General Data Protection Regulation. And we have time to, I think, go over the highlights, rather significant ones, just a little bit of history. The General Data Protection Regulation, or GDPR, was actually proposed in 2012 by the European Commission. And the process for this type of change, of this magnitude, is that the European Commission, the Council of Europe, and the European Parliament all have to ultimately agree on what that change is going to be, if it's going to be a regulation and therefore have the force and effect of law. The regulation was ultimately on May 5th of this year, so just about 12 days ago, it was formally ratified by those three bodies. And then after a 20-day publication period in the Journal of the Council of Europe, then the clock starts ticking on the 2-year implementation period. So suffice to say, by May 25th, 2018, the General Data Protection Regulation will be in full force and in effect. And it should be said that a lot of countries are actually relying, at least in principle, on some of these changes, even in some of the pronouncements right now. So, like anything else, there's going to be a little bit of conflating between the two, and we have to be aware of those changes, therefore, even more importantly. So some of those changes are a one-stop shop for the EU data protection oversight, a single data protection authority responsible for managing the data transfers between data controllers or companies and others in the United States. Fines of up to 4% of the gross annual revenue, or up to 100 million euro, whichever is greater, are going to be in place for violations. There is a right to be forgotten provision, also known as a right to erasure of information that has become stale and no longer is valid. There'll be privacy by design or default requirements. This is a big one for companies that use information systems, sometimes the very large ones like PeopleSoft and the like, to manage personal information. Starting in 2018, there will have to be controls in place to be able to segregate EU personal data from non-EU personal data, and to establish that controls are in place for the security and management and oversight and inspection of that data going forward.
Well, we have a couple of questions related to that, and with just 8 minutes left, I thought I'd jump in with them. One of them is, with personal data being broadly interpreted as anything identifying an individual, including something as simple as a work email address, how can a multinational company allow internal communications between EU and U.S. employees and still stay within the scope of the new changes?
One way they can do it is to pursue binding corporate rules that would provide that mechanism. In certain cases, model contract clauses would be helpful as well in the interim before we have a new privacy shield type of arrangement in place. Under the General Data Protection Regulation, binding corporate rules are fully adopted as a mechanism of choice for providing this kind of ongoing accountability and transparency in terms of these transfers. But there's no doubt that in this period of time that we are kind of a ship without a rudder, and the best you can do is the best you can do, which in this case is have model contract clauses in place in your highest risk transfer situations, and two, if you don't have binding corporate rules, take a look at seeking binding corporate rules, and three, make sure that that your representations don't run afoul from the FTC perspective of what is required under U.S. law, under Section 5 of the Federal Trade Commission Act. Just a couple other thoughts here. Data protection officers may be required, depending upon the impact of the data and number of persons involved. And of course, the judicial redress provision is also a change that is a predicate or an important part of this General Data Protection Regulation. And it kind of raises the ironic situation of us having exported to Europe the kind of class action mentality that we've struggled with here in the United States for quite some time. It'll be interesting to see how that plays out over time.
A related question then, do EU data privacy protections attach to personally identifiable data of U.S. citizens sent from the U.S. to the EU, or do the protections apply only to citizens of the EU?
The protections...
Go ahead.
Exactly. The protections only apply to citizens of the EU. As Jim discussed in the beginning, there's this long-standing desire for privacy in Europe because of the events of the past, and that's really the reason the EU directive evolved in the way that it did. Although that being said, I think there's an expectation that personal data will be handled appropriately in Europe because they do place such a high value on the protection of this data. So to that extent, when there is U.S. citizens' data being transferred to the EU, I think there's that underlying understanding or idea that it will be protected, but the EU directive itself only extends those protections to the EU citizens' personal data.
Okay, so even if they're traveling, so if it's a U.S. citizen traveling in the EU to perform work, that person's still not covered, right?
Under the direct. Go ahead, Jim.
Yeah, I think it's still an open question, at least until the General Data Protection Regulation comes into effect, as to whether that person, the data that they create and receive while they're in Europe, working on behalf of the European company, is entitled to some level of protection. I haven't seen any cases on it. It certainly will be an interesting one to follow as time goes on. We do know, for example, though, EU personal data that's stored in a central server, say in Texas in the United States, is certainly still subject to the European Data Protection Directive and will be subject to the General Data Protection Regulation. And there'll need to be some basis for the processing and the transfer of that data.
Okay, we've got 4 minutes left for your final takeaways and final thoughts.
I just think I'll jump in first and let you conclude, Jim. I think as we discussed today, it's evident that there are a lot of moving parts and that it's really important for organizations to continue to track what is happening as the laws evolve, as the directives evolve, as the DPAs in countries start implementing implementing these directives and how things are going to play out. Because right now we're still trying to feel our way around. We're seeing what's happening with the Privacy Shield and the GDPR, and it's just there's a lot of open questions, as we both said repeatedly today. So it's really important for organizations to keep abreast of the developments and stay plugged in and make sure everything that they're doing is as up to date as possible.
Yeah, and I think some of the things I would highlight in terms of a strategy for preparing for the General Data Protection Regulation and to dealing with the current, rather ambiguous standards and environment is, if you're a data controller or a data processor that previously relied on safe harbor framework to legitimize processing and transfer of personal data, you take a look at your contracts, take a look at your privacy representations, and make sure that they're consistent with what you're actually doing or can do. Secondly, consider mapping the personal data that you are needing to transfer from the EU. And it doesn't make sense to create a European data center where the EU data can be housed rather than transferred to the United States. But certainly identify those areas where the most sensitive personal data actually does need to be transferred from the EU to the U.S. Think clinical trial information involving pharmaceutical companies would be one example. You want to implement model transfer agreements relying on the model contract clauses as much as possible now in this interim period between data controllers, processors, and suppliers. You might, in my view, want to at least try to get in line for the binding corporate rules process, because this is adopted in full by the General Data Protection Regulation. appointing at least a functional data protection officer that can have a handle on these data transfers and be the spokesperson for the company to a data protection authority is very important. Look at your internal data privacy, data security, and data protection policies and protocols. And then, think in terms of investing time and effort to establish rapport, if you haven't done so already, with the data protection authorities of the various countries in which you engage heavily in sales and marketing and business activities in Europe, because at the end of the day, it does become, to a great extent, about relationship and about who they choose to make their poster child for enforcement. So you certainly want to do what you can to communicate clearly, completely, and frequently all the things that you're doing to be a good data protection citizen globally. These strategies will inure to your benefit not just in the bilateral situation with the EU, but also globally in countries all throughout the world, including those that are part of the Asia-Pacific Economic Cooperation Group, or known as the APEC, and their APEC cross-border transfer framework protocols, which are somewhat different but have a lot of similarities to the types of safe harbor principles and now privacy shield principles and soon to be GDPR principles for the handling of that kind of data.
Well, Emily and Jim, thank you very much for sharing your time with us today. I'd like also to thank Ipro for sponsoring this webinar. For those who are attending, please take the time to rate the webinar. Let us know how we did. There's both a 5-star rating and a place for comments. And with that, I'd like to thank all of you. And hopefully see you next time. Thank you and goodbye.
Thank you so much for joining.
Thank you for joining.